I'm Dr. Barry, licensed psychologist, and here we talk about true crime and psychology. Thank you so much for joining. Let's hop right into today's topic. Let's go.
Welcome. After a recent decision was appealed, I wanted to talk about some news. So I've been following Shanda Vander appeal. She was convicted of the death of her son, Timothy Furlan. He had autism. Sounds like he was a phenomenal kid. A lot of people had questions about why the father wasn't charged because Shanda wasn't supposed to have custody of him. She had lost custody of the children but it was in a different state, and I think there would have been issues between Michigan, the other state. If he hadn't died from his injuries, I don't know if the original state might have decided to do something. I don't know what would have happened. It really truly is a sad case, and I have multiple videos with a more detailed history of what happened. I wanted to real quick go over the fact that her request for a new trial was denied. She tried to blame her attorney, and her attorney did his best with the client and the facts that he had. And the judge released so there was an order covering everything. Let me just pull that up. So the defendant was convicted by a jury of one count of first-degree felony and one count of first-degree child harm. I can't say that word this early in the video. Following sentencing, the defendant filed through counsel a motion for a new trial and requested an evidentiary hearing. And it goes into more details about that hearing. The testimony of Fred Johnson, defendant's trial counsel, and deputies Catherine Evans and Timothy, I might be saying it wrong, but it looks like Levine, supports a finding that although the defendant may have experienced psychological and emotional distress at points during the trial, she still could understand the nature of the proceedings and was able to assist her counsel in rendering her defense. The only evidence that contradicts that finding was the testimony of the defendant herself. As discussed below, the court does not find the defendant to be a credible witness. I love it when judges because she's not a credible witness. She's not a credible reporter. The things she said during the appeal hearing, it didn't really make sense. So she says that she had a panic attack. She says that her became sick in a trash can. It's my understanding they looked in the trash can and she was dry heaving. There was nothing in the trash can. And while, yes, being on the stand and all of that can be an emotional process, she was, in my opinion, my personal thoughts, I do not know this to be true. My personal thoughts is that she was pretending to throw up to make it look like to the jury that she was sickened by the image of her, of Timothy because he was down to 69 pounds. 69 pounds. And there's a text from Paul, her other son, her adult son, who was also convicted in all of this. There's a message from Paul saying, I think we should feed him, or can I feed him? Something to that effect. And I believe she said no to that. And because even Paul was like, I think he's getting too thin. And she would not, she wouldn't do it. During her appeal, she tried to attack the fact that her attorney didn't bring up that dehydration, and none of her responses, nothing in her appeal, in my opinion, made any sense. And I am not surprised that any of those things happened. The judge was not finding her to be a credible witness. My heart goes out to the family. impact statements by the surviving sister and the surviving brother. Those were just really heartbreaking. And I believe I have prior videos covering that. Let's go into more of what the judge had to say. The remaining matter for the court is the defendant's argument that she was denied the effective assistance of counsel during her trial. The purpose of the effective assistance guarantee of the Sixth Amendment is not to improve the quality of legal representation. The purpose is simply to ensure that criminal defendants receive a fair trial. And so that's where, even with more recent cases, we're all looking like the defense could have done something better. Like, we all have thoughts about what a defendant's attorney could, or what we think maybe they should have done. But just because they didn't do those things doesn't necessarily mean that it'll rise to the level of ineffective assistance of counsel. I'm not a lawyer. I am reading the judge's brief. Those are just my general thoughts, having followed a lot of court cases. To demonstrate the denial of effective assistance of counsel, a defendant must first show that trial counsel's performance was deficient, or that the performance fell below an objective standard of reasonableness, such that counsel was not functioning as the counsel guaranteed by the Sixth Amendment. Defendant bears the burden of proving that counsel's representation was unreasonable under prevailing professional norms, and that the challenged action was not sound trial strategy. And to me, everything that she was arguing about with her attorney, Fred Johnson, to me, it fell within his trial strategy for her case, because she was really upset that he attempted to say, well, if it's anything, it's manslaughter. Like, if it's anything, because he was trying to get the jury down from first degree. And that's what they convicted her of. And the jury, and I don't know if the judge includes this, but it's my understanding that in debriefing the jury, the jurors struggled with, okay, could it have been something less? And the jury decided no, it wasn't. But her attorney at least drew their attention to, hey, if you're going to find her guilty of anything, like, she had no intent, there was no malice, even like she's sadistic. You can't. But Mr. Johnson wants to live in the world that I would like to live into, where normal people don't do this. And yet there is still evil in this world. There are still bad things that happen. He wanted there desperately to be something wrong with her. And I think she had multiple mental health evaluations, and everybody was like, there's no diagnosis that would make her less criminally responsible. Absolutely nothing. And so they were unable to get a mental health professional to say that there was something wrong with her. Let me continue on with the judge's statement. The defendant first alleges Mr. Johnson was deficient by allowing trial to proceed, knowing that his client was incompetent. She wasn't incompetent. She also argues that Mr. Johnson allowed her to sign a written waiver of her right to be present at trial, knowing she was incompetent. There was nothing that says that she was incompetent. This assertion is contradicted by the testimony of Mr. Johnson, as well as another witness, Melissa, I can't say her last name, Koteki, I think it's Koteki, a master's level social worker assisting with defendant's case. Both Mr. Johnson and Miss Melissa had extensive interactions with the defendant throughout the trial, and particularly the morning of December 15th, 2023. Miss Melissa's testimony was particularly compelling to the court, given her educational and professional experience in the field of social work. She testified that on the morning of December 15th, the defendant was very anxious and had pressured speech, but did not appear to be experiencing psychosis or catatonia. So if somebody is in a catatonic state, they can't move, not responding. It would be a severe sign of something very wrong. Miss Melissa also testified that the defendant was oriented to who she was and that a trial was ongoing in which additional witnesses would be called. As to the waiver, Miss Melissa testified that the defendant appeared to understand the concept of a waiver of her courtroom appearance and clearly expressed her desire to exercise that option. And I think she wanted the jury to think, I am so emotional, I'm so distraught, I'm so emotionally that I can't even return to the court. And I honestly think that was all part of Shanda's mental game, that she was losing control of the narrative, because to me she's very much somebody that needs control. She needs to be in charge of everything, and she kind of showed some possible like OCD personality traits. I can't diagnose her, I'm not trying to diagnose her, but she just seemed like a very rigid individual. I remember when they were going over the pre-sentencing report, like she was having them correct minor things, like really, like there should be a comma here, a space. I'm exaggerating. I don't know that it was a comma and a space, but she was having them correct her degrees. Now, I think a part of that was for her, like, I think she also had some narcissistic type traits too, where a part of that was protecting her image and she was trying to come off extremely accomplished, and yet somehow she missed this major neglect with her son, which I think she was a big part of that. She is, but to me, the judge hit it well. The judge was trying to give her every opportunity to present information that could possibly go in her favor, but it just didn't. She just didn't. And so the final order goes on to say yes, okay. Oh, the defendant, according to Miss Melissa, was apparently appreciative of the waiver being offered to her and relieved she did not have to appear in court again. Mr. Johnson's testimony was substantially similar to that of Miss Melissa, albeit in more layman's terms. The defendant's testimony on the issue was unconvincing. Her recollection of the events on the morning of December 15th was clouded by self-proclaimed lapses of consciousness, which can't be confirmed by anybody else. I think she was saying she was dissociating or something, that conspicuously occurred at times critical to the issue of her competency. This self-serving amnesia, which she also had I'm adding that she also had. So she also had self-serving amnesia for the crime as well. Oh, I don't remember. Oh, I must have been so overwhelmed. I don't remember. Like, she had cross amnesia bad. And so the judge is mentioning this self-serving amnesia that just so happens to happen at times that bring up where we're talking about her competency. It was substantially similar to her trial testimony when she claimed she could not remember the interactions or communications with her co-defendant that would support her criminal culpability, but could recall most other events surrounding the death of her son. To put it bluntly, she is an incredible historian. To put it bluntly, she is an incredible historian. Like the way that she remembers things, she can break things down. She remembers it, this date, but then you ask, well, what about this? That could, if it's going against narrative she's wanting to say, all of a sudden it's amnesia. The court finds that Mr. Johnson's conduct as to the defendant's competency was not unreasonable and was sound. Defendant also argues that Mr. Johnson was ineffective because he failed to search for or call an expert witness who could support defendant's assertion that her loss of memory was legitimate and the result of underlying mental illness. Despite this assertion, the record demonstrates that the defendant was evaluated by 3 potential experts. The Center for Forensic Psychology conducted separate competency and criminal responsibility of examinations on the defendant. The examinations were performed by separate physicians. The reports that were generated following those examinations would not have been favorable to the defense. In fact, just the opposite was true. The reports indicated that the defendant's claims of amnesia were not medically reported, appeared to be selective. She has selective memory for the crime. Mr. Johnson consulted a third potential expert, Dr. Colin King, yes, who has extensive experience in the field of forensic psychology. Dr. King could also not support the defendant's claims of memory loss or mental illness. Mr. Johnson's decision to stop his search for an expert after 3 separate physicians had been consulted was not unreasonable. Defendant next argues that Mr. Johnson committed prejudicial error by failing to highlight dehydration as the cause of the victim's death. Mr. Johnson's avoidance of this issue was not accidental, but intentional. So Timothy died in a bathtub, and he testified that his strategy at trial was to focus on the issue of intent versus negligence and not on the cause of the victim's death. Specifically, he wanted to convince the jury that the defendant did not form in her mind the requisite intent to harm or cause injury to the victim, which the jury did not buy. She was super duper, just very, very guilty, and the jury convicted her. The thrust of his argument was that the defendant's actions were reckless or negligent, but she did not intentionally harm her son, which the jury disagreed with. Mr. Johnson also wished to prevent the prosecution from highlighting the fact that the victim was submerged in cold water, which caused him to suffer hypothermia. While defendant's current counsel may have chosen an alternate approach, the court finds that Mr. Johnson's trial strategy was sound and reasonable. All right. Yeah, she literally, like, I think her lawyer, her appellate lawyer, she wanted them because I think the cause of death was dehydration. And they were like, but he died in water. But it were not really, but like they wanted to bring that part in, but no, he was only 69 pounds. And they were severely limiting his food, his water, everything. They were doing horrific punishments. It was some of the worst testimony I've ever listened to. There is a video. I will not watch it. I don't recommend anybody watch it, of Timothy's last moments. And I highly recommend that people protect their mental health and not look at those images, not look at any of that. I highly recommend that. The court next turns to the argument that Mr. Johnson should have objected to portions of the testimony of Lieutenant Joel, I can't say his last name, Hoksima? I don't know, who was called to describe a video of the victim hours before his death. A portion of that testimony described the victim's eyes as being open, but not really seeing anything. The defendant argues that the statement was lay opinion testimony. The court disagrees. Following the statement at issue, the lieutenant further stated that the victim appeared to be unresponsive and didn't speak at all. Okay, I'm just going to skip over some of that testimony because it's describing what happened in the video. And Mr. Johnson said one of the best things he did was made sure that the jury did not see that video. The deliberations would likely have been 2 minutes, 5 minutes, 10 minutes. The deliberations would have been short if the defense had not stipulated to that video just that it could be described, but that the jury did not see it. The judge goes on to say that is not opinion testimony. It is the lieutenant describing what he observed the victim's behavior to be. As to the lieutenant's testimony that he was concerned watching that and seeing the victim's appearance, that testimony was objectionable. However, an objection by Mr. Johnson at that point would have highlighted that testimony for the jury. And that's what I was trying to mention that to somebody today, that sometimes the defense, even if something is said that they would like to keep out, Sometimes objecting to it makes a jury focus on it more. And so he chose to not object at that time. It was not unreasonable for Mr. Johnson to simply allow that testimony to pass, especially as Lieutenant did not continue to comment on how he felt about the video. In addition, the court cannot find that Mr. Johnson's failure to object to the testimony prejudiced the defendant. Finally, the defendant argues that Mr. Johnson was ineffective when he conceded in his closing that she was guilty of involuntary manslaughter and not intentional murder. The record establishes that the defendant clearly asserted and maintained her innocence of any intentional crime throughout the pretrial and trial stages of this case. However, according to Mr. Johnson, the defendant was aware and acknowledged that a jury could find her guilty of a negligent or unintentional crime. Because of this, the goal of the defense, Mr. Johnson stated, was to convince the jury that the death of the victim was the result of negligence rather than intention. Mr. Johnson discussed this overall strategy on multiple occasions with the defendant, including during pretrial preparation. The defendant never objected to this strategy or asserted her innocence of unintentional or negligent crimes. It's on video. Mr. Johnson testified that the defendant left the decisions on how that strategy was implemented to him, because he really felt like she trusted him, but I think she was hanging him out to I think she was being sneaky back there. And so they are exactly where they belong. Initially, I had some when Paul testified, he came across very different than he did during his police interview. He came across much more like a victim. And so initially I was just like, like I felt sorry for him. And then I went back and watched his interview with the police right after the crime, and also listened to some of his jail calls. And no, he was just as sadistic, and my thoughts. Now, I think he was also a victim of his mother when he was younger as well, but Paul is right where he needs to be too, in my personal thoughts and opinion. Let me see. Right. So, all right. The Sixth Amendment guarantees each criminal defendant the assistance of counsel for his defense. Trial management is the lawyer's providence. Counsel provides his or her assistance by making decisions as to what argument to pursue, what evidentiary objections to raise, and what agreement to conclude regarding the omission of evidence. So this just goes on to be like, Mr. Johnson did his best. Ultimately, the defense's strategy culminated in Mr. Johnson's argument to the jury that the defendant was guilty of involuntary manslaughter. I think I went into that part. Mr. Johnson testified that the defendant did not specifically authorize the concession, but that it was consistent with the overall defense strategy. He did not concede guilt to any intentional crime consistent with the defendant's objectives. And so, all right, he lists some trial law, and then let's see. All right. Mr. Johnson testified that he would have lost credibility with the jury, and they would have never listened to what he had to say if he argued the defendant was entirely inculpable for the death of her son. He cannot be deemed ineffective for attempting to impress the jury with his candor and willingness to engage in a useless charade, I guess. That's in quotes. I don't. Especially when his arguments to the jury were made with the consent of the defendant. Even if trial counsel's performance was deficient, a defendant must show that the deficiency prejudiced the defense. To demonstrate prejudice, and then he goes on to describe that, because the jury didn't even find her guilty of manslaughter. She was on the top charge. So he was like, if she's guilty of involuntary. That's what he said. And they were like, no, she's guilty of first degree redrum, however you like to YouTube friendly say that word. So this all ends with a reasonable probability is a probability sufficient to undermine confidence in the outcome. The evidence of the defendant's guilt in this case was overwhelming. Assuming, and they have Italian arguendo, I don't know, like so let me look up this word. I don't know if that's Latin. It's probably Latin. They have a word and I don't know what this word means. And so we're going to figure it out together. Ooh, arguendo. Ooh, is a Latin legal term that translates to for the sake of the argument. Okay. So for the sake of the argument, let's just say that, let me find my sheet. There we go. That Mr. Johnson's performance was deficient. This court cannot find that there is a reasonable probability the correction of those errors would have resulted in a different outcome. For the reasons stated above, the defendant's motion for a new trial is denied. It is so ordered. Honorable Matthew Cassell. I might be saying that wrong. Circuit judge. So, that was that. After finding out that Adam Montgomery is being given the chance for a new trial, that one hurt my heart. I hope that they are able to recover her body. Harmony Montgomery still has not been recovered. And my heart breaks for her surviving brother. I don't know if they'll tell him, because maybe he doesn't need to know that his sisters, but they might have to call his adoptive father again. I don't know if his adoptive father, I forget if he testified during the trial or if he testified or if he just made a victim impact statement. I'm not sure. I do believe that Adam Montgomery will be convicted again. I do think he will be. I get that defendants have rights, and a court felt that because he was charged with a prior assault and then also her death, and a court ruled that those two shouldn't have been tried together. So when judges make decisions, I'm always like, oh, I hope that holds up on appeal because everything the judges do. So if a judge allows something that shouldn't have been allowed, that can prejudice the jury, that can prejudice the process, we have to do the whole process all over again. I do hope he's forced to be in court this time. He was able to not attend last time. I think they're going to have to call Kayla again. Kayla, I don't know if they're still married. I don't know. I wish she had gotten more time. It is what it is. It is what it is. Her testimony helped solve the case. The statements that she provided, and she was offered a deal. And, but her, boy, it's a very difficult case, but I will be following that one. Tomorrow, we will be talking about the Netflix documentary. Ooh, there are some good recaps. So Kathy from Gossip Rumor and Innuendo, she did a recap that came out today about maternal instinct. Very triggering. It's a lot. If you don't want to deal with something that talks about the death of a child, just watch Kathy's recap if you would like. If you follow Hidden True Crime, I did watch Dr. John's evaluation or just his thoughts on it. And I've also watched some other coverage, and I will be coming to you all tomorrow at 6 p.m. to talk about that one. Yes. So this documentary is about Taylor Parker. She is currently facing the death penalty. It's a lot going on in that case, but we are going to talk about, I found information about her former therapist. They did come to some ideas about her personality. So I will talk about, because often when horrific things happen, we kind of want to make sense of it. Now, I think there's a piece of this that is just nobody should ever do what she did to anybody. And so there's a piece of this that won't ever fully make sense. But I do just want to break down some things. and also talking about HIPAA, because there were some warning signs, but I think um, if I had received a warning like that, I likely would have had to reach out to my liability insurance to say, would it be against y'all's? Could I make an anonymous call to the police? Like, I'm concerned about what I've been told by third party people. Can you do a welfare check? Can you? I don't know. Like, I might have been concerned. Sometimes therapist versus medical doctor. Sometimes there are different rules and requirements. I will have to check. So I know for us as a psychologist, I have a duty to warn. If I'm aware, like if my client made a threat against somebody else, I have a duty to warn that person. That comes because of the Tarasoff decision. Because unfortunately, I think it was a university in California. I want to say it was like USC or something. Unfortunately, there was a tragic event where a guy told his therapist he was having thoughts about harming somebody. That individual was never warned and didn't know to stay away from him or any of those things. She unfortunately passed, and a law and ethical guideline was created in her honor. And so that is the Tarasoff decision. And so as a therapist, I have a duty to warn. I don't know about medical doctors. So if they're concerned about the mental health of their patient, and what if it's not their patient that told them? We're going to talk about that tomorrow. All right. So we will talk about that. I so appreciate you all. I will see you all tomorrow. Be kind, don't do crimes, and I will see you all next time. Have a good one. Bye.